And we're back. Welcome to the Law&Crime Network. I'm Michel Bryant with you for the afternoon session. We are in the Charles Merritt case, the penalty phase out in California. Jury on a break right now, so this gives us a great chance to chat. Darryl Cohen is my guest, entertainment and criminal defense attorney, currently in Atlanta. He's been an Atlanta ADA. He's been a former state attorney for the Dade County folks in Florida. First of all, thanks, Darryl. I appreciate the appearance and the info I'm about to suck from your brain. Let me ask.
I have no brain, so let's go.
You're already running low? Okay, I'll take it easy. Let's talk about the California death penalty. You live in Georgia, death penalty state. Florida, we're very well aware, death penalty state. In California, something kind of weird's going on there. Technically, yes, they have the death penalty, but earlier this year, the relatively new governor, Gavin Newsom, put a moratorium on the death penalty. So there's 737 inmates on death row there. Remember in South Carolina, we talked about Timothy Jones Jr. He was the 36th on death row, to give you some perspective. They last executed somebody in California in 2006. That was Clarence Ray Allen. You might remember him, hired somebody to kill 3 folks. The curious thing, and let me get your take on this, Darryl, this appears to be the governor's idea. The voters in California have voted not only to uphold the death penalty, they voted a few years ago to speed up the process and cut out the appeals process to some degree, because it takes an average of 25 years for a death penalty convict to be executed in California. Give me your thoughts on all that.
Well, it seems to me that the governor has taken it upon himself to override what the people have said, and he has decided that the death penalty is inappropriate. What I think might change his mind is if a friend or relative was brutally murdered, then just maybe he might see reality and might see day rather than night.
So what would you say to folks who are against the death penalty for one very simple reason? It's wrong to execute even one innocent person.
Well, I agree with that. As a former prosecutor, I never wanted to see an innocent person executed, but then there's reality. Reality is that 99.9% of the time, the person or persons who have been convicted of a crime are guilty. Now that we have DNA, we've gotten rid of the visual evidence in a way. We have guaranteed this is the way it happened, this is who did it, this is why he did it, this is who he was or who she was. So DNA, in my view, has made prosecution far easier to make sure that the jurors get it. I mean, there are jurors that feel, oh my gosh, I can't really convict him or her, because if I did, and if I was wrong and they get the death penalty, I could never live with myself. But now with DNA, we augment all of the other evidence that we once had, and it just slams it.
Okay, you segued perfectly into my next point here. In this case, in the Charles Merritt case, DNA is a huge issue because apparently there were 3 unknown DNA samples found at the burial site that the prosecution never pursued, never sent to CODIS, never did anything with. And there's a case in California that Newsom kind of piggybacked on former Governor Jerry Brown's move to do additional DNA testing to make sure they have the proper guy. This is the Cooper case, Kevin Cooper, accused of stabbing 4 people to death back in '83. That case is now back to life on the DNA front, because they want to make sure, to your point, they want to know that they got the right guy. What about this Merritt case? Are you sure they got the right guy?
Well, I wasn't the investigator. I obviously wasn't the prosecutor, and clearly I was not the defense lawyer. But after looking at all of the evidence, as I have, looking at, for instance, the tire tracks, though they can't say it was exactly his truck, it matches his truck, matching all of the evidence as I see it, I don't see how they don't have the right guy. And you have to also keep in mind, though 12 men and women juries are the same throughout the United States, they're really not the same. We come from different backgrounds, and California, for the most part, has a more liberal bent. So you have to prove not only beyond and to the exclusion of every reasonable doubt, you almost have to prove to these 12 men and women there is no possibility of a doubt of any sort.
Which is kind of an artificial heightened standard, because that one doesn't really exist anywhere. But I get your point. They are a pretty liberal state, and now they're having to deal with whether or not to put this man, at least philosophically, to death. Although based on our conversation, it's highly unlikely he would ever actually be executed. It's far more likely I think he is 60-ish now. He's going to die from old age before he ever dies from an injection. So it's a fascinating situation. I can't wait to see how it plays out in California. That's my home state. And we're going to find out how this case plays out, too. Stand by, Darryl. We've got much more to talk about, and we're going to go back into that courtroom for a look at some of the prosecution closings as we wait for the defense closings in the merit penalty phase. Stay right where you are. We'll be back.